Imagine that a heating repair company contracts to purchase a boiler from a manufacturer, but then repudiates by declining to go through with the purchase. If the manufacturer has no trouble selling the boiler to another customer, is the repair company still liable for damages? In Teradyne Incorporated versus Teledyne Industries, we explore a seller's remedies under the Uniform Commercial Code. Teledyne Industries contracted to purchase a transistor test system from Teradyne Incorporated for the list price minus a $984 discount. Just prior to Teradyne's shipping the system, Teledyne repudiated the contract by informing Teradyne that it wouldn't proceed with the purchase. Teledyne offered to buy a different product instead, but Teradyne refused the offer. Teradyne subsequently sold the original system to another buyer for the full list price. Despite selling the system to the second buyer for a higher price than that contracted with Teledyne, Teradyne sued Teledyne for breach of contract to recover damages. Teradyne presented evidence that if Teledyne hadn't breached the contract, then Teradyne would have made two sales instead of one. Consequently, Teradyne argued that it was entitled to recover lost profits equal to the contract price minus costs saved because of the breach. Teradyne didn't consider employee labor costs to be costs saved by the breach. The district court ruled in Teradyne's favor. Teledyne appealed to the First Circuit, arguing that the district court erred in its calculation of Teradyne's lost profits because employee labor costs should have been deducted from the contract price.